Section 18 of the Act addresses the referral of dispute to alternative dispute resolution form. In simpler terms, it states that under this Act, the utilization of alternative dispute resolution forms is primarily regulated by Chapter 2. However, if ADR is combined with arbitration, then the rules and regulations pertaining to this combined process are covered by Chapter 5 of the same Act. This provision ensures clarity on the governing rules depending on whether the dispute resolution involves standalone ADR or a combination of ADR and arbitration.
Chapter 4, International Commercial Arbitration. International Commercial Arbitration, or the ICA, is a private dispute resolution process in which parties from different countries choose to have their dispute decided by one or more arbitrators, without the involvement of the courts of a particular country. Section 19. Adoption of the Model Law on International Commercial Arbitration. Section 19. International commercial arbitration shall be governed by the Model Law on International Commercial Arbitration. The Model Law, adopted by the United Nations Commission on International Trade Law on June 21, 1985. United Nations Document A4017, and recommended approved on December 11, 1985, copy of which is here to attach as Appendix A.
Hello guys, my report is Section 20, Interpretation of Model Law. In interpreting the model law, regard shall be had to its international origin and to needs for uniformity in its interpretation, and resort may be made to the TRAVAX Preparatory and the report of the Secretary General of the United Nations Commission on International Trade Law, dated March 25, 1985, entitled International Commercial Arbitration Analytical Commentary on Draft Trade, identified by reference number ACN 9264. Okay, the interpretation of model law typically refers to understanding and applying legal framework such as the Unicitral Model Law on International Commercial Arbitration. This model law provides a standard set of rules for the conduct or arbitration proceeding. Interpreting the model law in international commercial arbitration involves adaptation to jurisdiction, consistency in application, compliance with international standard, balancing autonomy and control, respecting due process, accounting for amendments. In overall, the interpretation of model law in international commercial arbitration aims to facilitate efficient and fair resolution of dispute in a manner that is consistent with international standards while accommodating the unique feature of each jurisdiction.
Section 12, Commercial Arbitration. Section 12, Commercial Arbitration. An arbitration is commercial if it covers matters arising from all relationship of a commercial nature, whether contractual or not. Relationship of transactions, any trade transaction for the supply of exchange of goods or services, distribution agreements, construction of works, commercial representations or agency, factoring, leasing, consulting, engineering, licensing, investment, financing, banking, insurance, joint venture, and other forms of industrial or businesses, cooperation, carriage of goods or passengers by air, sea, rail, or road. So ito sa ang commercial arbitration ay isang paraan ng pag-aayos ng mga hindi pagkakaunawaan sa pamamagitan ng pagre-refer sa kanila sa isang neutral na tao or arbitrator na pinili ng mga partido para sa isang desisyon batay sa ebidensya at mga argumento na iniharap sa arbitration or tribunal.
Section 22. Legal Representation in International Arbitration. In international arbitration, conducted in the Philippines, a party may be presented by any person of his choice, provided that such representative, unless admitted to the practice of law in the Philippines, shall not be authorized to appear as counsel in any Philippine court or any other quasi-judicial body, whether or not such appearance is in relation to the arbitration in which he appears. Dito po sa Section 22, pwede po tayong pumili ng kahit sinong tao na magre-represent sa atin in international arbitration, especially if we are involved in international dispute or commercial dispute that involve foreign state. Yun nga lang po, dito, kailangan din po natin tignan kasi may bawal din po. Sabi dito, shall not be authorized to appear as counsel in any Philippine court or any other quasi-judicial body na magre-represent sa atin in international arbitration.
Confidential of arbitration proceedings. Arbitration proceedings, including the records, evidence, and the arbitral award, shall be considered confidential and shall not be published, except 1. With the consent of the parties, or 2. For the limited purpose of disclosing to the court of relevant documents. In cases where resort to the court is allowed therein, provided, however, that the court in which the action or the appeal is pending may issue a protective order to prevent or prohibit disclosure to documents or information containing secret processing, developments, research, and other information, where it shown that the applicant shall be materially reduced by unauthorized disclosure thereof. Example, this passage outlines confidentiality in arbitration proceedings generally. All aspects, including records, evidence, and the awards, are to remain confidential. However, there are exceptions. Consent of parties or limited disclosure to court when permitted. The court may issue protective orders to prevent disclosure, especially if it could materially harm a party.
Section 24. Referral to arbitration. A court before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if at least one party so requests, not later than the pre-trial conference or upon the request of both parties thereafter, refer the parties to arbitration unless it finds that the arbitration agreement is null and void, inoperative, or incapable of being performed. So, this section pertains to instances in which a court case is brought pertaining to a subject matter that is covered by an arbitration agreement that the parties have already in place. For the matter to be sent to arbitration, the court must receive from at least one party. The pre-trial conference is the deadline for submitting this request. Nonetheless, following the pre-trial conference, both parties may jointly request referral at any moment. Court's obligation. The court is obligated to refer the parties to arbitration unless it finds that any of the following apply. First, null and void. The arbitration agreement itself is invalid or legally unenforceable. Second, inoperative. The arbitration process cannot be initiated or carried out due to practical or legal barriers. Last is the incapable of being performed. It is impossible to resolve the specific dispute through arbitration due to its nature or complexity.
Section 25. Interpretation of the Act. In interpreting the Act, the Court shall have due regard to the policy of the law in favor of arbitration, where action in command by or against multiple parties, one or more of who are parties who are bound by the arbitration agreement, although the evil action may continue as to those who are not bound by such arbitration agreement. Ang Section 25 ay naglalaman ng pagpapahalaga sa patakaran ng batas na nagbibigay prioridad sa arbitration. Ang arbitration ay isang proseso ng pagsasayos ng alitan o di pagkakasundo ng isang neutral na pamagitan at nagsasabi ng batas.
So the next section is section 26, meaning of appointing authority. Certainly, the appointing authority refers to the individual or entity designated in the arbitration agreement to select arbitrators or resolve disputes regarding their appointment. This authority can either be specifically named in the arbitration agreement or can be a recognized arbitration institution as per the agreed upon rules. If the parties opt for institutional arbitration governed by specific arbitration rules, they are typically bound by the procedures outlined in those rules for appointing arbitrators, unless they've mutually agreed on an alternative process. However, in ad hoc arbitration not administered by an institution, if there is no agreed upon procedure for arbitrator appointment, the default appointment will fall to the national president of the Integrated Bar of the Philippines or IBP or their authorized representative.
Hello everyone, this is my report. Section 27, what function may be performed by appointing authority? The function referred to Article 11.3, 11.4, and 14.1 of the model law shall be performed by the appointing authority unless the latter shall fail or refuses to act within 30 days. From applicant may renew the application with the court. So, ang pagkaintindi ko ay the model law refer to the authority of the appointing authority to appoint an arbitrator or a sole arbitrator in case of a dispute. If the appointing authority fail to act within 30 days, the applicant may renew the application with the court. This means that the court will have the authority to appoint an arbitrator or a sole arbitrator to resolve the dispute.
Hello ma'am, my report is section 28, grant of interim measure of protection. Paragraph A, it says that it is not incompatible with an arbitration agreement for a party to request before constitution of the tribunal from a court an interim measure of protection and for the court to grant such measure. After constitution of the arbitral tribunal and during arbitral proceedings, a request for an interim measure of protection or modification thereof may be made with the arbitral tribunal or the extent that the arbitral tribunal has no power to act or is unable to act effectively. The request may be made with the court, and the arbitral tribunal is deemed constituted when the sole arbitrator or the third arbitrator who has been nominated. has accepted the nomination and written communication of said nomination and acceptance has been received by the party making request. Section 28 states that it is all about regarding the safety or security of a person. And in paragraph A, it says that before you will request an interim measure protection to the court, you should go first to approach the arbitral tribunal to seek a protection. Unless arbitral tribunal is not allowed to release a interim measure protection, and that's the time to proceed at the court to make a request for interim measure of protection. Paragraph B. The following rules on interim or provisional relief shall be observed. 1. Any party may request that provisional relief may be granted against the adverse party. 2. Such relief may be granted. And next is to prevent irreparable loss or injury. It is necessary to secure ourselves, especially if there's a threat from the other party. And next is to provide security for the performance of any obligation. It states that it is important also to seek a interim measure of protection so that our daily lives or daily routines, like our obligation, will not be affected, especially at work if you are an employee. And next is to produce or preserve any evidence. The purpose of this, the interim measure protection security is not all about yourself. It is also about the evidence that you have to secure the evidence against the other party uh, to destroy it. And next is to compel any other appropriate act or omission. It states that we will prevent any illegal things that possible will happen to us while arbitration process is ongoing. 3. The other granting provisional relief may be conditioned upon the provision or security or any act or omission specified in the order. In number 3, it states that it is important to prevent any other acts or omission. Paragraph 4. Interim or provisional relief is requested by written application transmitted by reasonable means to the court or arbitral tribunal as the case may be, the party against whom the relief is sought, describing in appropriate detail the precise relief, the party against whom the relief is requested, the grounds for the relief, and evidence supporting the request. Paragraph 4, the purpose of paragraph 4 is if you will request a grant of interim measure protection, it should be in written application so that the court or the arbitral tribunal will be acknowledge your concern. In paragraph 5, the order shall be binding upon the parties. In paragraph 6, either party may apply with the court for assistance in implementing or enforcing an interim measure ordered by an arbitral tribunal. Paragraph 6, it states any party have the right to apply this grant because the court or arbitral tribunal is fair for both parties. And paragraph 7, a party who does not comply with the order shall be liable for all damages resulting from non-compliance, including all expenses and reasonable attorney's fees paid in obtaining the order's judicial enforcement. This paragraph states that a party who requested a interim measure security must comply to the conditions of the court. example, Mr. X and Y is the both are the both parties, and the Mr. X is the one who requested a interim measure security in the court, and the court conditioned him to do not talk or do not communicate within 50 kilometers radius to Mr. Y. And if Mr. X violated the conditions of the court, he will be liable for damages resulting from non-compliance, or including expenses or reasonable attorney's fees.
I report Section 29. Further authority for arbitrator to grant interim measure of protection. Unless otherwise agreed by the parties, the arbitral tribunal may, at the request of a party, order any party to take such interim measure of protection, as the arbitral tribunal may consider necessary in respect of the subject matter of the dispute following the rules in Section 28, Paragraph 2. Such interim measures may include but shall not be limited to preliminary injunction directed against a party, appointment of receipts of detention, prevention, inspection of property that is the subject of the dispute in arbitration. Either party may apply with the court for assistance in implementing or enforcing an interim measures ordered by an arbitral tribunal. Section 29 outlines the further authority granted to an arbitrator to use interim measures of protection unless otherwise agreed upon by the parties involved in the arbitration. Take the key points includes: Number 1. Arbitral tribunal's authority. The arbitral tribunal, upon the request of a party, is empowered to order any party to undertake interim measures of protection. Number 2. Nature of interim measures. The nature of these interim measures is broad and may cover various actions that the tribunal deems necessary in relationship to the subject matter of the dispute. Number 3. Reference to Section 28, Paragraph 2. The rules for taking interim measures are the be followed as per Section 28, Paragraph 2. Number 4. Example of interim measures. The next provides example of interim measures include but not limited to preliminary injunctions against the party, appointment of receivers, detention, prevention, or inspection of property that is the subject of the dispute in arbitration. Number 5. Application for court assistance. Either party involved in the arbitration has the right to apply to the court for assistance in implementing or enforcing an interim measures ordered by the arbitral tribunal. In summary, Section 29 is emphasizing the authority of the arbitral tribunal to order interim measures for the protection of the parties involved in the arbitration process. It also acknowledges the possibility of seeking court assistance for the implementation or enforcement of such interim measures.
My report is Section 30, Place of Arbitration. Section 30 allows parties in arbitration to choose the location for proceeding. If they don't agree, it default to Metro Manila unless the arbitral tribunal decide otherwise based on the case circumstances and parties' convenience. The tribunal can also meet in any suitable location for discussion, hearing, or inspection unless there are different agreement by the parties.
Section 31. Language of arbitration. Language of the arbitration refers to the language used in the arbitration proceedings. It is important to determine the language at the beginning to ensure the effective communication. The choice of language is influenced by factors such as party proficiency, location, laws, and contract language, but if they don't, the arbitral tribunal may decide. The language affects written submissions, oral arguments, witness testimony, and the final award. Translation or interpretation services may be needed. Overall, the language of arbitration is crucial for fair and efficient process.